6 critical documents exist that all United States property owners above age 60 must complete, yet the majority fail to do so. When these individuals pass away, the absence of such paperwork ends up costing their offspring the family residence. Let me guide you step by step through each individual document, the precise, clear-throat financial impact that each provides, and which sequence to complete them in. That fifth document on our list represents something 90% of elderly individuals remain unaware of until relatives find themselves inside probate proceedings listening as a judge determines ownership of their deceased parent's property. That particular one comes shortly. However, initially, comprehending why such situations occur matters most. Our nation's probate framework wasn't built for protecting households. Instead, it generates income for state judicial systems, plus compensation for legal professionals operating within them. Consequently, each calendar year, countless thousands of families across America forfeit significant sums of money. Occasionally, the complete worth of their family dwelling occurs because those who established this framework failed to inform them regarding these 6 critical documents that prevent such losses. The majority of such paperwork requires under $200 for filing. Several options are entirely without charge, yet without awareness of their existence, this framework claims funds you intended for your offspring, leaving your relatives powerless to prevent it following your passing. Below are these 6 documents arranged in their proper completion sequence. That initial document determines whether your offspring spend $20,000 or spend absolutely nothing. The name is Transfer on Death Deed, occasionally abbreviated to TOD. This paperwork accomplishes one objective, yet represents the most crucial item throughout this entire list. It permits you to designate which individual receives your residence immediately upon your passing without that property entering probate proceedings. The significance of this cannot be overstated. Average probate proceedings throughout our nation cost families roughly 3 through 7% of total estate worth. Consequently, for property valued at $300,000, your offspring pay approximately $9,000 through $21,000 covering court costs, legal representation expenses, plus executor compensation prior to receiving the property title. Yet financial loss isn't even the most damaging aspect. Within certain states, probate proceedings require 9 through 18 months for completion, throughout which property cannot be sold, cannot receive refinancing, and cannot even undergo cleaning. Real estate taxes remain due. Insurance coverage must continue being purchased. Any existing mortgage must continue receiving payments. Your offspring cover all such expenses during their waiting period for judicial permission to access their own deceased parent's residence. Transfer on death deeds eliminate this entire ordeal. You complete it once through your county recording office, and upon your passing, ownership transfers immediately to whomever you designated on that paperwork. 0 court interference, 0 legal fees, plus 0 waiting requirements. Such forms are obtainable in approximately 30 states. Determine whether your state permits it by looking up the phrase transfer on death deed alongside your state's name. Filing costs in the majority of counties range from $20 through $60, however. Transfer on death deeds only function when actually filed prior to your passing. The majority of individuals discover this information too late. Consequently, this represents paperwork you cannot postpone until next calendar year. That second document is something federal authorities prefer you remain ignorant about. Its designation is Ladybird Deed. This particular option exists only within 5 states: Florida, Texas, Michigan, Vermont, plus West Virginia. Should you reside within any of these 5 locations, pay extremely close attention throughout the following 60 seconds, since this single piece of documentation can shield your property from a danger that devastates households daily throughout our country. Here's its function. Ladybird deeds permit you to maintain absolute authority over your residence throughout your lifetime, including selling rights, refinancing rights, or rental rights. However, immediately upon your passing, that real estate automatically transfers to whomever you identified on that deed. It operates almost identically to transfer on death deeds, aside from one vital distinction. Ladybird deeds shield property from Medicaid estate recovery. I discussed the Medicaid 5-year look-back regulation in a different video on this channel. However, here's the condensed explanation. Should you ever request long-term care Medicaid during your final years, federal authorities possess legal authority to return following your death and mandate selling your residence to recover every dollar Medicaid expended on your medical care. For typical nursing facility stays lasting 3 years, that equals approximately $240,000 through $360,000 authorities can claim from your estate. This is where households lose everything. Ladybird deeds legally extract your residence from your estate the instant you pass away. Consequently, nothing remains for authorities to recover. Your offspring inherit property free and clear. Even should you spend your final 5 years receiving Medicaid, however, Ladybird deeds must be filed plus recorded prior to ever requesting Medicaid. Should you delay, look-back regulations cancel protection. Consequently, should you reside in one of these 5 states and own property, this represents documentation requiring discussion with an estate lawyer this month, not next calendar year. Once you need it, that window has already shut. That third piece of documentation saves households more funds than anything else throughout this entire list. However, it's also where individuals commit the most costly error. Its name is Revocable Living Trust. Trusts cost more for establishment than those first 2 documents, approximately $1,500 through $3,000 depending on legal counsel. However, here's why it's worth every cent. When placing your residence into a revocable living trust, property no longer belongs to you legally on paper. It belongs to that trust. You maintain full authority. You can sell, refinance, or relocate at any moment. Nothing regarding how you live gets altered. However, since property is technically owned by that trust, it doesn't belong to your estate upon your passing. Consequently, it cannot be affected by probate. For $400,000 homes, this single action saves your household $12,000 through $28,000 in probate costs alone. However, trusts accomplish something even more significant than that. Trusts provide you specific directions for how property gets managed after you're gone. Should you have 3 offspring and 1 resides in the property and the remaining 2 desire to sell, trusts can specify exactly what occurs. Should you desire the surviving partner to reside in property for their remaining lifetime and only afterward have it transferred to offspring, trusts can accomplish that. Should you desire to shield property from a future divorce of one of your offspring, trusts can accomplish that too. Wills cannot accomplish any of these objectives. Wills get read inside.